So welcome everyone to this third module of Heart and Soul of Leadership. We already had a session in December, trying to respond to this call of being called to leadership. And in January, we had as well another module on teamwork, how to go about it, how to know ourselves in this reality that we are leading together in a synodal way. And today, March of 2025, we will have a session on canon law. As leaders, as general counselors, you need to know how to go about many, many things. And one of the tools that you need to know and have, it's canon law. What does canon law say, and how does canon law help us and help you to discern and to help your sisters in this journey that we are doing together in consecrated life? So today we have with us Kelly Connors and Maren Rose. Both of them are sisters. And Kelly will be speaking first on accountability and discretion. So I'll introduce her now, and then I will introduce Maren Rose later on. So Kelly, thank you so much for being with us. Kelly is a presentation of Mary's sister, and she's born in the United States. She completed her studies in canon law at St. Paul University, Ottawa, Ontario, Canada, with a specialization in religious law. So she, since then, has helped many congregations, many superior generals, many sisters in many areas of religious life, and also helping in dioceses, teaching at universities, giving retreats on religious life and the vows, and also providing workshops, conference for religious and their collaborators, and consultations. So she's a good friend of UISG. She's worked with us for a long time. She also served one term as general counselor, and currently she works as a part-time at the Dicastery for Institutes of Consecrated Life and Societies of Apostolic Life. So she'll be speaking to us today in English, but if you need her help, she also speaks Italian and French. Kelly, thank you so much for helping me the first time to draw this program, Heart and Soul of Leadership, that then was enhanced and took forward with other people.
Thank you, Paula. It's great to be with you. It's my joy to be with you today, all of you, and I hope that we can have some good conversation. Know that I remain available if you have questions. I'm happy to hear those questions. Paula is going to help us navigate that, so you can write your questions either in the chat or you can use the hand raising function, and I'll be happy to answer some questions. You know the topics that we'll be discussing during these 3 days, so try to keep the questions with the topics that we're having, because I know it's so tempting to want to cover everything, especially your burning questions right away. So know that we will get to your questions, especially if you write them in the chat. We can address them as we discuss that particular topic. I say this morning, I'm in the United States, so it is morning for me. So whatever time of day it is for you, today I'll be beginning with an introduction of kind of the general approach to canon law. Many of us come to leadership, and our impressions of canon law are things to be avoided, right? It's those things, we have this baggage of history that says canon law is that thing that suppresses us, that puts us in a box, And so we want to do everything we can to not have to deal with canonical issues. But you know, our current Code of Canon Law is part of the fruits of the Second Vatican Council. The law of the Church, which canon law is based on the gospel. And it, in this particular version of the Code of Canon Law, our second version in the history of the Church, is the fruit of that discussion in those documents of Vatican II. It's the implementation of the documents of Vatican II into the day-to-day life of the Church. Yes, there are some rules that are a bit more strict or rigid, but it's about organizing the life of the people of God in this communion of the Church. So the goal of the law is that unity and that harmony moving together towards the kingdom of heaven. And that's how we hope to approach it. Now, how do we understand law? I think you know from your various cultures how we approach law is different from place to place. In the United States, we follow the law because if we don't, we get in trouble. We can go to jail, we can be fined. That's the motivation to obey the law, to avoid the negative consequences. But canon law is written in the code model. And the code model presents the ideal. It lays it out before us, that which we're striving for. And our constitutions, our law for our congregation, our proper law, is written in that same modality, isn't it? Our constitutions are very inspirational. This is canon law. Your constitutions are canon law for your congregation. And even if it's written in an inspirational way, that's on purpose because it's presenting the ideal that we are called to strive for together. It's the law for us. Oftentimes, people will say to me, what does canon law say about a given topic? And I tell them, I said, canon law doesn't say anything about that. What does your constitution say about that? Whenever you have a canon law question, the first place you go is your constitutions, if it has to do with your congregation. This is where you find that information and exactly how it applies to you. If your constitutions say we follow the norms of the universal law, then you look up in canon in the Code of Canon Law. But the first place you look for any question on canon law is your constitutions. Because here we present the vision that we desire to achieve or are on our way to. Because we know there's no perfection this side of heaven, right? And so we are on the way, day by day, growing, learning, becoming. So this is our common agreement also. A lot of times people will ask me, what do we do when someone doesn't do what they're supposed to do? And why don't we have laws about the negative things? People say nowadays, there needs to be more in the Code of Canon Law against abuse of authority. Why isn't there anything on abuse of authority in the law? Because that's not our vision of leadership. It says very clearly in the canon on the role of the superior that her ministry is one of service. Her authority given by God is that of service. The vision that we put forth in the law is the promotion of the good. When we look at the vow of obedience, we say, well, what do we do when a sister doesn't go where she's assigned to go? It doesn't say anything in our constitutions. Right, because the presumption is she understands her vow and the obligations, and she will go where she has been legitimately sent. It's that vision that we want to promote and that we're striving for together. We don't define our law by the repercussions of the negative. What do we do when someone does not live according to this vision? But the reality is that our constitutions are a mutual contract of that which we are striving towards together. And everyone who is a member of the Institute has asked permission to live their life according to these constitutions. It's part of the vow formula. And so that we presume that everyone who is a member desires to live this as it is articulated in our proper law. Now, just to be clear, the Code of Canon Law is the universal law for the whole church. In dioceses, we have particular law. Sometimes there are those things within the diocese that are unique, and we call it particular law. It is particular to this diocese. And then those things relevant to our religious congregation, it's our proper law, the law proper to us. Okay? And it's the constitutions, it's the second book, the directory or directives or whatever, if you call your constitutions the statutes, any other kinds of handbooks or guidebooks, or a provincial handbook, the superior's handbook, the treasurer's handbook, the formation handbook, all of those things that we legislate for ourselves or for a particular group of our members. Okay, that's all our proper law. And in our proper law, it is full of rights and obligations. For every obligation, there is the converse right. And for every right, there is the converse obligation. I was speaking to a group of sisters, and one sister said, "Oh, I'm so happy for you that you have so many rights in your constitutions. Mine is full of obligations and very few rights." And I laughed. And I said, "No, sister, it's how we read it. It might be written in the sense of an obligation, but it also has the corresponding right. I have the obligation to make an annual retreat, but I also have the right to make an annual retreat. And how I enter into that retreat may be colored by how I see that one number in our constitutions. Am I carrying out an obligation, or am I living the freedom of my rights? I have the obligation to live in community, but I have the right to live in community. And both as an obligation and as a right, there are implications for how I am to participate in that community. So we try to help recognize our approach, the openness of the law in how it is written as that ideal towards which we're moving. And that striving together to live in this way how we are called to carry out the gospel, to witness to Jesus Christ together in this modality of our proper law, unique to our charism and mission, gift to the church, to the world, this unique gift of the Spirit that is each of ours. Okay, so that's just a little introduction on how we approach the law, because oftentimes we see canon law as that strict thing that tells us what we cannot do or what we must do. But it's really the guide to the path that we're called to follow towards that our ultimate goal of union with God. It's our path to holiness if we allow it to be. Are there any questions just on that intro or comments? It's not necessary. I want to offer a possibility if anyone has anything. I It would need to be a little bit more context of how are they using the constitutions to refuse. The only legitimate manner of refusal as if it is a matter of conscience. When a sister refuses an obedience, the constitutions say, what is it that the superior, in the end, after dialogue and participation and whatever means, it is for the superior to decide. If a sister refuses without sufficient reason for the superior to reconsider, then she has to understand the consequences of that refusal because she has agreed to the fact that the superior has the right and the obligation to decide for the good of the institute. And so if the sister refuses to go, acknowledging the obligations of her vow of obedience, then she has to be ready to accept dismissal for her refusal. It doesn't say in our constitutions that we have to accept where we're being sent. But the ideal proposed in the Code of Canon Law is that obedience is a submission of wills into the will of God through our superiors in this occasion, in accordance with our proper law. So if the superior is carrying out the obligations according to proper law, she has the consent of her counsel, and it is a legitimate request that the person has no substantive reason to refuse other than a matter of conscience, which we cannot force her to reveal, then she must obey. And failure to do so, she needs to understand, could be cause for dismissal. Sometimes our sisters are bullies, and they think if they're stubborn enough, we'll give in. And we have, because it's just easier to let these people, we don't want to fight. But their power then grows with their refusal, and it becomes harder and harder and harder to promote that vision of communion and the gift that is ours, our charism, of following the gospel. It becomes harder and harder to build that up when we have the fracturing of people doing their own thing. So yes, it's absolutely difficult and inconsistent with who we say we are And so you do, as leaders, you do what you believe is right for the sake of the mission, carrying out your proper law with integrity and the striving for holiness for all of your members. And if that means somebody is going to push up against you, you be ready for that as well. Okay? Again, the only reason somebody can legitimately refuse an obedience is if they say it is a matter of conscience. And that's in the universal law. And we don't really put that in our constitutions, but that's the only reason. And somebody who has studied the question and really believes it down to their toes that they cannot say yes, they will articulate it. They might not say it's a matter of conscience, but if that's what you receive as they speak with you, you can decide if it's something that you wish to respect or challenge. Okay? Thank you. Is there anything else, Paula? Mhm. That's very true. And that's one of the reasons I went into canon law, because I could not believe that that was how the church intended its law, as a weapon. Because if we are a church that follows Jesus, the Jesus of the Gospels, that is not how he used the law. And as I read canon law, it is not how it is written. But yes, that is how we have learned to use the law. But when we read our constitutions, is that how we understand them? No, because it is the obligation from the universal law is that our constitutions are to be a harmonization between the spiritual and the juridical. We do certain things, we have certain rules, but the motivation why we do what we do for the sake of the kingdom, in imitation of Christ, these are all of the aspects of why we do these things. And the rules, the structures are there meant to keep us on this path of holiness in response to the unique call that we have to consecrated life in the church with a particular charism and mission. Because the charism recognized by the church as gift to the church and the world must be, because it's a gift of the Spirit, must be lived in the world. And so how do we carry out that vision together? Through the structures of our constitutions. On Wednesday, we'll talk more about structures and constitutions, because right now, in the time since Vatican II, people have started looking at revising our constitutions again. And so I want to talk a little bit about that, but we'll do that on Wednesday, okay? But thank you for the comment. It's very true that canon law can be used as a weapon to keep us in line. But I don't believe that that is the intention in how it was written. It can be how it is used, but that's not how we arrive at the ideal of following Jesus Christ. Okay? Okay, I will go on to one little couple of things, because we're going to talk about our basic areas that are important for you in your ministry and how you work together as a team, okay? So it's about that accountability, and then we'll talk a little bit about discretion. So one of the things that often gets caught up in confusion is this: as you work together, every superior has her counsel. That's the premise of the law. And so the counsel is not separate from the superior, but is there, and I've seen in many of your constitutions, is there to support and advise the superior. The counsel is meant to be that support, not just a group of people that says yes, 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 but a support of offering the various perspectives that each one has to share that gift of herself and the perspectives that she offers. In the law, there are, in your proper law and in the universal law, there are occasions where the superior needs the consent or the advice of the council in order to act. So there, in those situations, the superior cannot give herself consent or cannot advise herself. This is meant to hear the voice of her counsel. It is presumed that the superior wishes to act because she's the one presenting the request. Now, it could be like someone has requested renewal of vows or admission to first vows, admission to perpetual vows. So it's not necessarily the request of the superior, but she presents it. And how do we articulate this? Some of you say in your constitutions, in a deliberative vote. That means consent, or with the consent of her counsel, or with her counsel, that it is a mutual decision. In these cases, it is more than half of the counselors who must support the petition for it to move forward. If the superior does not have more than half of her council supporting the petition, it cannot be acted upon. Now, if I have 4 counselors and 2 say yes and 2 say no, I do not have the consent of my council. However, if my constitutions say that the superior can break a tie in the case of a tie, that the superior can break the tie, then you have that right to do that. However, I go back to, it says, with the consent of her council. If I have 2 and 2 of my counselors, I do not have the consent of my council. And I emphasize this because, especially at this moment, it is part of our history, but especially at this moment, as we speak of a synodality or a synodal means of acting, we want to hear and respect the voices. And if half my council does not support this action, do I want to proceed? Even if I have the authority to break the tie, is that the manner I wish to proceed? If I have the consent of my council, 3 or 4 of my counselors say yes, they are giving me the freedom to act, but they cannot force the superior to act. Because of the right of privacy of our members, there may be a situation that I know of that I cannot share with my council, that the member has asked me not to share. And so I say, thank you for your consideration, for your response, and the seriousness of your evaluation with regard to the information you had. However, there is something that I am not able to share with you that prevents me from saying yes. I need a very serious reason to go against the consent of my counsel, but it is possible. So again, a counsel can prevent a superior from acting because she needs the consent to validly carry out the action, but they cannot make me do something by their consent. I have asked their consent, their permission. They have said, yes, I do not need to use that permission. Okay? When I am told by my proper law or the universal law that I need the advice of my counsel, I need to consult my counsel. And even if we vote, it's consultative, but it's tell me what you think. Each member must be heard. If I do not hear my counsel, the action taken is invalid. So you see in the bottom in the indication of Canon 127, although not obliged to accept their opinion, even if unanimous, a superior is nonetheless not to act contrary to that opinion, especially if unanimous, without reason, which is overriding the superior's judgment. In the superior's judgment, okay? So that's just that distinction and the role of the counsel. In the next paragraph of that same number, and this is Canon 127, which is in the general norms. So it's for the entire, all decisions, not just in the situation of religious superiors. All whose consent or counsel is required are obliged to offer their opinion sincerely. And if the gravity of the affair requires it, to observe secrecy diligently, and moreover, the superior can insist upon this secrecy. So the two aspects of it, discretion, that those things that are discussed around the table of the council are meant to stay there. And in so doing, each counselor is called forth to offer her opinion, not what we think the superior wants to hear. Understand this well. You were not elected to just nod and smile. But to give your opinion, you must be well informed. You must have the information needed to give an opinion and the time to reflect on it. Your job as counselor is to speak your truth, to seek the common good. You are here at the service of the whole congregation. And so your desire is not for your way to be the one chosen, but what is the good, and to speak that opinion sincerely. However, whatever decision is taken, once you have been heard, it is also your role, once you leave that council meeting, to support the decision. It might not have gone in the way that you would prefer or would like to have seen or wanted it to go, but the decision was taken justly according to the constitutions, and that the superior is believing that she is acting for the best of the institute. And so once you leave that room, that decision is unquestioned to the rest of the congregation, that you support that decision. It is the decision of the superior. You have given your consent or you had given your advice, but the decision is that of the superior. And we do not wish to build a divided house. Even if I don't agree with the decision, I keep it to myself because we are seeking and striving for communion. Remember that vow of obedience that says we seek the submission of wills into the will of God. And so even as being a part of that decision making, I too must strive for that submission of will. If I were the superior, I might have done it differently, and that's okay. We're all different. We have our strengths and our weaknesses, our gifts and our vulnerability. It is her task. I have spoken my truth, and now I support her in her decision. Do you see? There is never a reason for me to go and talk to the people in a province that had a decision, for me to tell them, oh, that wasn't a good decision and don't follow it. No, there is nothing. Nothing comes from the fruit of that discussion in the council except by way of the superior. There is no back door. There is no, because that is divisive. We do not wish to build a divided house, but we find God's grace in all that we do in action. But the obligation for me is to speak, to give my opinion sincerely. I can't vote yes and then say, oh, that was a terrible decision. I don't know why she did that. Because I voted yes. It's finished. I had my opportunity, and if I didn't say it there, I don't say it. Okay? According to the norm of the constitutions, superiors are to have their own council, whose assistance they must use in carrying out their function. This is not an optional thing. Not just those things that it's spoken of requiring consent or advice for validity. It is our way of functioning. You see this Canon 627, whose assistance they must use in carrying out their function. It's part of the design of our whole structure that we have this synodal dynamic. No one person has all the gifts, and so we depend upon others to help us see different perspectives for the good of the Institute. So again, you may put it in your constitutions in different ways. Having heard the council, that would be advice. With the council decides, that might be consent. In the cases where it says collegially, and sometimes together with her counsel, could be interpreted as a collegial decision where all of the council and the superior vote equally, and the superior collegially, the superior is obliged to carry out the decision made. So this is one of the things having to do with dismissal. It's a collegial vote according to canon law. A secret ballot. Everyone votes, every vote is equal, and the superior is obliged to carry out the decision of the collegial vote. So there's different levels of accountability that we carry out with this responsibility. The superior is accountable to the members of the Institute. So she is called to communicate with her sisters, to give updates, to gather them, to have as much transparency as possible in making decisions and yet respecting the privacy of individuals. I find it very helpful, and it's a mentorship, that if I'm a superior, I explain how I arrive at a decision. If I am a local superior, if I am head of a ministry, at all phases of our religious life, if we can speak about how we come to our decisions with one another, we mentor people in decision making so that when it comes to their turn to make decisions with integrity, they have heard and learned from each other. And so that doesn't need to stop when we arrive at the general administration. So to be transparent in how I came to this decision with the fundamental desire of the good of the Institute, right? And how is that reflected through the decision that was made? That's part of my accountability in my role as superior to the members of my institute who have called me to this service. We are accountable to the bishops where our members are present. And this communication, we want to assure that this communication is open and that the structures of our internal governance and how our members are accountable within the congregation are respected by the bishops. And so communication with the bishops can only be helpful, that they understand that if there is a province in the provincial superior or the regional superior, or if there's one house, the local superior communicates with the bishop, but she is accountable to her superiors with regard to the internal life and structures of the institute, of assignment of members, of the various things. In some places, bishops want to choose who is here, there, and everywhere. And so the communication with them assures us that they understand our structures, our responsibilities, and our rights, okay? And then we are accountable to the church through the periodic report, which is to be submitted to the Dicastery of Institutes of Consecrated Life and Societies of Apostolic Life. Usually, we submit this after a general chapter because most of the information is already gathered for the report, the superior's report to the general chapter. So it's just out of convenience. There is no set definition of what this periodic report, how often. It has just fallen into the rhythm of chapters with communities. So if you go to the website of the dicastery, there are several languages that you can find this in. And you go to the section where documents are listed. And there's a link to the guidelines for the preparation of the periodic report. Okay? And yes, I think the document was issued in 2008 or 2009, but that is the most recent set of guidelines. And it's guidelines. It's not an exact ding, 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 ding. You must answer these questions, but you can have it organized in the manner that you organized it for your report to the general chapter. But just ensure that the various elements that are requested are included. Okay? Questions or comments? Now I open it up to you. What would you like to ask? And are there any questions already? I'm looking for my Code of Canon Law. I don't find it. The Code of Canon Law is universal law. It is that law of the church for the whole church. Proper law is our constitutions. It's the law proper to us. It will be at least as if the universal law says the superior must have the advice of her council. That's the minimum. Our proper law might say, for this case, the superior must have the consent of her council. We can oblige a stronger accountability, but we cannot offer less. So if the universal law says, in the case of somebody being accepted to novitiate, the superior needs to hear her counsel or have the advice of her counsel. We cannot say the superior decides if somebody can be accepted to the novitiate. We cannot do less than what the universal law says. But we could say the superior needs the consent of her council to admit someone to novitiate. We can oblige more than the universal law. And we are bound by our constitutions because it is proper to us. It's only for sisters of this congregation, all sisters of this congregation. And we have agreed that this is how we will find our life together. It's the contract that we sign, so to speak, in living together under this structure, definition, vision of this path to holiness. Okay? If there is a tie, then you do not have the consent of your council. You need more than half for consent. If your proper law says that the superior may break a tie, then the superior may break the tie. May break the tie. But the request has been, and this is my own canonical opinion, the request has been for the consent of the council. If there is a tie, I do not have the consent of my council. It does not mean that you can't discuss it further and perhaps come back to it at another moment, have some more discernment and discussion or information. But as we are called to deepen our sense of synodality, and we're striving for communion, do I want to act on something that has not seen the support of my council? That's all. If your constitutions give you the right to break the tie, and that's what you need to do, then you do so. If your constitutions do not say that the superior can break the tie, then she cannot. Because the question was asked early on to the Pontifical Council for the Interpretation of Legislative Texts that said, can the superior vote to break a tie? And the answer came back as no. The voice of the superior cannot mitigate the role of the council. It cannot be dulled down, the voice of the council. This is why we have councils, to advise. Correct. And oftentimes I see in constitutions as they're being proposed, they say the general council, members of the general council are the superior general, the vice, and I'm like, no, the superior general is not a counselor. She is a member of the general administration, but she is not a member of the general council. Do you understand? And maybe, well, that's what we mean, right? And that's fine as long as you understand. But when we, every little bit helps us to be clear. And so we know we're talking about the general administration, but we call it the general council. But the superior is not a member of the general council. Again, she does not advise herself. She does not give herself consent, but she cannot act without hearing the voice of her council. And so this breaking the tie is overriding the voice of the council. And she may have that authority, and that's how you carry that out. That's fine. You still need if you have four counselors, one abstains, the other three still need to say yes, because it's of how many possible votes, not how many actual votes. The striving is always for the good of the institute. And in our role of the general administration is to look at the whole. We're there because of the experience that we have had being in that part of the congregation. We come with a different lens, and we have been elected to speak from that lens. So it's not to frustrate the actions that are being taken, but it is to speak sincerely from the perspective and experience that I have. But again, if I can't, if the decision goes in a way that is not my preference, if I have been able to speak my truth, then I need to let it go and let the decision proceed, because it's not my decision, but it is my obligation to speak the truth as I have experienced it, that which has surfaced in my own discernment for the good of the whole. You know, every one of you, of the 580 sisters that are a part of this conference today, have had the experience of finding that distinction between the good of this piece and what is best for the whole. And we're called to see with that broad vision as much as possible in this capacity. Okay? So, yes, I have personal experience, and I will share at the table. You know, this is what you've all heard from people that are feeding you information. Here is my experience of that place and the filter that that information is coming to you with. And that's all I can do, is to speak honestly from my experience. Yes, it's you follow your constitutions. And I have seen constitutions that say the decisions are collegial decisions. In those cases where it says that these decisions are collegial, all members vote, the Superior General and the counselors, and she is obliged to carry out the decision of the group. The challenge of this is it could block movement. It could stifle circulation. It could be a way of manipulation and control by some members of the council. It's not it's not the healthiest way to function in our global mentality. And yet, at the same time, the more we root ourselves in the synodal dynamic, the more we hope that this is the reality, that we move forward together in communion. And so a collegial vote each time does foster that. But in our frailty, it could really frustrate some situations. But what your constitutions say, that is what you have the right and the obligation to exercise. So you are not bound by this whole conversation I just had about consent. Okay? Follow your constitutions. What does canon law say? Well, you follow your constitutions. And I know that there are many questions around this, and each one we have to look directly with your constitutions. The superiors are to be as transparent as possible, but we also want them to have that capacity to respect the privacy of individuals. Um, one more question. It's difficult. With the means of communication that we have today, could we not have at least done a conference call before the decision had to be taken? If it's not possible, then the superior should make a temporary decision, but not one that is, for now, we will do this, but I'll get back to you, to consult with her counsel that we're seeking communion. We're seeking the good of the Institute. Yes, there are emergencies, but really, unless it's a matter of life and death, things can wait. We've come to see everything as urgent. But do you remember the time that requests came to the general administration through mail? And the letter would take a month to arrive. We'd wait till the superiors had their meetings, and then it would take a month to return. Right? And then we got telephones that we could call, but we only called rarely because it was very expensive and the time difference. And then we got fax machines. And now we have instant messaging. So we've come to see things as very pressing, but they might not be as pressing as we would think they should be. Or we've over-centralized and don't form our sisters to be good decision makers in subsidiarity at the level to which the decision can and should be made. So it's a point of personal evaluation and how we approach the structure. But in as much as possible, we want to follow a discerning path and not a reactive path. The number of counselors, it's usually preferred to have an odd number, but it's not always possible. And we propose the odd number so that there aren't the situations of a tie. But it doesn't mean it can't work. It's just a matter of um, striving together. So we need a break. We take how long, Paula? 15 minutes, 10 minutes? Thank you. Thank you. And I'll look at the questions if I can download those questions. Uh, yeah, I'll do that so that I try to attend things at least on Wednesday, or Martin and Rose can also address some of the questions. Thank you.
So thank you very much, Paula. It is evening here in Nairobi, so whatever timeline. So in Nairobi, we say God is good all the time. So I also want to thank Sister Kelly for the nice presentation. And I will continue on the next part of our presentation. That is, we are going to look at alienation of property in religious institutes. I hope you can hear me. Okay. So we would like to look at the topic of alienation. And we begin by a small introduction to say, we have been entrusted by God with gifts. And as we have in the book of 1 Peter, chapter 4, verse 10, each one of us has been entrusted with a gift to serve others as faithful stewards of God's grace in various forms. That ideally, what we own in our institutes, we own it in trust. It is for the mission of Christ expressed in our charism and in our lives. So our goods are not ends in themselves. They are, at best, that which we have been privileged or we have been gifted to have, so that we may live well and carry out the mission effectively. So when we come to alienation, we want to understand what are some of the canonical requirements or provisions around alienation of the property that we own. That means we have something as an institute, and for a just reason, we want to change ownership of it to a different person, to a different group. And one thing we must take note of, what is it that we have? Is it possible to give it to another person to own? If we give it to another person or to another group, are we going to suffer in any way? Is it going to cause us some harm? Or it's going to limit the way we live, the way we serve? So all these questions have to be part of our discernment and discussions when we want to transfer ownership of what we have. Not that we give everything, because the Bible says, give your property to the poor and come and follow me. Not that way. We also need in the past something, as the disciples were told, have something. What Jesus was about is the extra. We need to have the tunic. We need to move, and we need to live, and we need to serve people. So we need the property so that the mission of Christ in our institute may be successful and fruitful. Therefore, we want to look at what is the canonical understanding of alienation. What is it that we can alienate and we cannot alienate? What do we need, or what requirements or what conditions must we fulfill before we convey or before we transfer ownership of what we have? And does it mean that in the institute, anybody can alienate any property? Are there those that are designated that have been empowered to do the alienation? So we want to look at all this in the short time that we have. So I want to begin by a small introduction of what I hope to look at this evening here in Nairobi, the meaning of alienation. What is it that we are alienating? It is the property owned by religious institutes. That is what we want to alienate. Then this property, who owns it and why and how? Then what is the canonical identity of religious institutes and their capacity to own property? And now, what will be the civil incorporation of institutes and their works? Because that also affects how we alienate and what we can alienate. Then if we have time, we look at challenges in alienation, especially lawful and unlawful alienations, and then consequences of unlawful alienations, and some changes that have been made in canon law, recent changes concerning ownership of property. So we can only alienate what we have. So alienation, as I've said, is the transfer of ownership or conveyance. So sometimes we want to sell something or give it away because it's more useful to another person or another group than us. And we are not going to suffer much harm or any harm by giving it away. Or sometimes we want to make what we have more fruitful. Like we would like to sell something so that we buy even a better thing, or the funds we get helps us to improve the property that we have for our works, for the purpose for which we have it. Sometimes we alienate because the things are so old that it is even unproductive, counterproductive to keep them. Or sometimes we are moved by the gospel spirit of helping our needy neighbor so that we can part from some of our property so as to help our neighbor who is struggling. So we have many reasons why we want to convey property or transfer ownership. But we cannot just wake up in the morning and say, we are alienating this. This one, we must give it away. Since what we have, as I'm going to explain, we have it as technically what we have is church property. And when we possess it in trust. Secondly, when we alienate something, we are going to lose something. It is a loss. We had it yesterday, and when we give it away today, that moment we have lost something. And the loss might not just be physical or material. Sometimes what we give away also goes away with our ability to operate, ability to express our charism. It also goes away with our identity. So it's just alienation goes beyond just transferring a material property. It might go with our heritage, our history, our traditions. Something that was identified with us also gets lost in the process of alienating. That's why we have to be very, very careful. We have to discern very well before we transfer ownership of that which we possess. You let me know if I'm going too fast. Okay. Okay. So as we look at canonical understanding of alienation, I would like to draw our attention to some of the documents that are very, very helpful, especially to those entrusted to administration of institute property. We have the circular letter that came from the dicastery in 2014. It is a guideline on how we administer our assets, and I would recommend that we all read it. A later document, which is more detailed and very, very comprehensive, is the guidelines on economy at the service of charism admission, issued by the dicastery 2018. So I recommend that we look at them. To begin with, I want to begin with a statement of when we are transferring ownership of institute property. One thing to underline is, am I acting prudently? Am I acting out of necessity and in the best interest of the institute and of the church? Those could form part of our foundations as we begin on discernment, especially when we want to alienate substantial property. So as I've said, the property we have it only as stewards. It is for fostering a more radical following of Christ. Let our possessions help us to follow Christ even in a better way. It is for deeper witness of living our consecrated life and for greater effectiveness in mission. So, in all our actions of administering property, we have to put all this in mind. So examples of acts of canonical alienation, okay, there are many ways in which we can transfer property, but I have just a few examples so that we may know, because sometimes we think it is administration or sometimes we are not sure. But some examples here are sale or transfer of property, spending all or a portion of the fixed or stable capital, which I'm going to talk about in a little while, leasing of property, borrowing of money, obtaining a mortgage, giving property as free gifts, sale of historical or precious works, and issuing of bonds, and others. We can, yes? Oh, I was not, imagine, I thought I was sharing it. I'm sorry. I'm so sorry. I need to, yes, sorry about that. Yeah, okay. So can we see it now? Okay. 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 I'm so sorry. I thought we were seeing it all because I was just scrolling it. So sorry for that. So I am saying alienation is connected to ownership. We can only alienate what we have. So it is imprudent to go and borrow money so as to give somebody. So we have to understand the nature of the property and the kind of property that we have, because that determines how and what we can alienate. Because if I am keeping somebody's money in the bank, then I cannot give it away. So we must understand, or we must have in mind that not everything that is in our possession might be exactly our property. So it must be that which we owned, not that which we are keeping for another group or another person. So when we go to property owned by religious institutes, we call them ecclesiastical goods. And ecclesiastical goods, what that means is, because religious institutes, as Kelly had already said, are juridic persons in the church and public juridic persons as such. That is equivalent to being a public corporation in a state with rights and obligations and legal identity. Therefore, by law of the church, juridic persons, which are public like religious institutes, are allowed to acquire, own, administer, and alienate property. But it has to be done according to the provisions of the law and the provisions of the proper law that Kelly talked about. That means that the church has outlined how these properties are to be categorized or are to be itemized. Religious property or property owned by the religious, as much as they are ecclesiastical goods, that technically they belong to the church because they are owned in order to fulfill the purposes for which the church has specified. Number one, take care of the members. Number two, enable the members of the institute to carry out their works. And number three, to help the needy of the church. That's why I believe most of our institute, we have the practice of almsgiving. But this is how our properties are required to be categorized. The property belonging to religious, there has to be some of it set aside called stable patrimony, that the institute will set aside legitimately designated property for the long-term security of members. This property, whether it is in form of funds or actual property, is not to be alienated easily and is not to be remitted to daily use or daily administration. The institute knows that that is set aside for future security. Then we may have historical or precious works, like those things that maybe our founders or the earlier members or was given to us and has been part of the heritage of the institute. Those are very precious property and cannot easily be given away without following the requirements of the law of the church. Then immobilized or assigned goods for a specific purpose. We may assign goods. These goods are only used for taking care of the health of members or taking care of formation. So those ones cannot just easily be again subjected to transference or conveyance without a very grave reason, but without following the laid out provisions for touching such kind of goods. Then we have entrusted goods. A group or some physical persons may entrust some goods to us. Those goods, as much as we may be administering them, they are not our own, so they cannot be alienated. Then any other goods that are belong to the institute from whatever moral and lawful source. Then we have goods that are in form of joint works or joint ventures. I will give an example. A religious institute has been entrusted to run maybe the hospital of the diocese, of which the written agreement was the sisters can continue to develop the hospital. They can build the staff houses and their own convent, and those ones will belong to them. But the land belongs to the diocese and the hospital. So it is one property, but there's joint ownership. Such property would be very difficult to alienate them because it would require the agreement of all the owners. Then donations attached with intentions. The donor gave the property, but also attached with it an intention. I have said religious institutes are public juridic persons. As public juridic persons, the institute exists as a whole, but we know it also has other internal divisions, like intermediate units, delegations, regions, provinces, which also exist perhaps in different countries in the world and are under particular churches or dioceses. So these internal divisions or units also form public juridic personalities. So they exist in those regions where they are, but they form part of the institute. So these units will operate in those countries respecting the laws of those countries and the manner of acquiring, administering, and alienating property. Yet, there'll also be authorizations required from the leadership in accordance with the proper law of the institute. So care has to be taken that those parallel sources or parallel source of authorizations have to be harmonized, so that when the central leadership of the institute gives permission for alienation, it is harmonized with what the particular law of the diocese says and what the law of the country says. Okay. Also, as I've said, these units and the whole institute must also be recognized by the state. So generally or usually, institutes will arrive in a country and will be incorporated in that country through the process of trusteeship or company limited. This will determine how they are able to acquire property and consequently alienate it. Sometimes other institutes, depending on the particular church through which they have entered the country or they have entered the region, it takes a long time before the institutes become independent. So they buy property through the diocese, and that is also another complications. So if their ownership is through the particular church, it becomes very complicated if they want to dispose of that property. So their civil identity is part of the diocese. So those are some of the complications we must know as institutes when we are dealing with alienation. So when we come to ownership of property in the institute is a juridic personality in canon law, but it is not a reality. We cannot meet the institute and greet it, that I'm greeting the institute. We know the institute is there, but it is a reality of fact. It's not a material reality that is the institute working. Therefore, for the institute to own property, it must own property through its agents. And as Canon 1279 states, whoever governs the institute is also the one who is entrusted with the property. And so the competent superiors by law are the one entrusted with the property to acquire, to possess, to administer, and to alienate. They are assisted by administrators, which we call different names: treasurers, bursars, economists. They assist the competent superiors over the stewardship of the property. So canon law do not call them owners. They are called stewards because they are simply entrusted with the property. Again, at incorporation, the institute will have what we call board of trustees, who in civil law will be the ones that transact business for this public organization that has been recognized in civil law. So, in order to alienate any property, all that must be taken into account. The internal permissions and the external permissions. So the internal permissions will have, depending on what to be alienated and what is in the proper law, the competent superiors with the consent of their council. So for the community to sell something or give away something, they may need the authorization of the provincial or regional. And regional, in order to alienate some property, will need the permission of the supreme moderator with the consent of the council. This will be specified in their proper law so that those systems are clear and members know the limits of which they would need what kind of authorizations. Then we talk of external permissions. Because property owned by religious is ecclesiastical property, the church has to ensure that religious institutes are not reduced into destitution because of misconduct or because of poor or unlawful alienations. So as a requirement of the law, Vatican requires each Episcopal conference to set limits of what an institute can sell or can transfer in a given a period of time. And these limits must be adhered to. And they differ from one country to another or one Episcopal conference to another. Institutes are also to respect the provisions or the limitations or conditions put by civil authorities on certain alienations. For example, there are certain buildings in certain countries which, even if the religious own them, the religious cannot give them away or tamper with how they are, because they are buildings of heritage. So I want to look at acts of alienation of which permission is required from the Apostolic See. I earlier on talked about the goods that we call stable patrimony. So if the institute is to alienate part of their patrimony, stable patrimony, they have to ask for permission from the Holy See. Contracts of duration of 6 years, like loans, housing, leasing, permission from the Holy See is required. Sale of several property or items or donation which exceed the maximum amount permitted for a region, by that I mean the Episcopal Conference, the competent superiors must seek for permission from the Holy See. Contracts of exchange of goods, alienation of precious and historical items, and need to resort to credit for financing new constructions or huge renovations whose cost will pass the maximum sum set, permission is required from the Apostolic See. So quickly, I want to look at documentation, or if the competent superior would want to seek requests for authorization from the Holy See. They have to give the minutes showing that he or she has sought for the consent of the council. Number 2, the reason for alienation. It must be just. not just we are tired, we want to sell. The description of the property to be alienated, and what is the use? What is the use? What are they going to use from the proceeds? At least 2 valuations of property, the purchase offer, who wants to buy it, audited financial statements, and a written opinion of the Daostan Bishop of the place where the property is. And if the request is from the province or a region, there must be evidence of support from the Superior General with the consent of a council, and a reference letter from the provincial or the regional. What will the Holy See consider when the Holy See is accepting the petition? If they want to an institute wants to alienate property in order to pay debts, the Holy See will also want to see the plan of economic and financial rehabilitation. Now that you are in debt, what are your plans for the future so that you are not in debt again? If the Holy See will not authorize sales of property so as to solve an immediate financial problem, the Holy See would want to know what caused that problem and how do you want to overcome it. So the Holy See will rely on the evaluations of property, their original cost, the declared value of goods for taxation purposes, their replacement or insurance value, their depreciated value, and there will be an invoice. Some money will be paid to approve the rescript for the alienation. So quickly, let me look at the challenges in alienation. Sometimes institute, we are not sure of what is administration and alienation of property. Okay. And sometimes we do not do enough discernment, correct discernment, because as I said earlier, it's not just selling property or giving it away. It might go with Catholic identity, our control to talk about our charism and spirituality in that work. Okay. And sometimes operations of alienations are not harmonized with the civil requirements. Lack of clear policies guiding administration of property, so that treasurers or administrators, they just do what they want. They can buy and sell at any time. And then lack of knowledge of canonical requirements, like what we are talking about. Sometimes we are not aware of the limits set by the conferences. We feel we can just sell anything at whatever amount. Sometimes we are not aware that some property cannot be alienated. And sometimes there's a lot of challenges to deal with property of joint ownership. And then procedural alienations can also land the institute sometimes even in more problems, more financial difficulties. And then in some institutes, we do not have property designated as stable patrimony. All property are the same. They can be sold, they can be given away. Then sometimes we have poor administration systems whereby accountability, reporting, financial practices are lacking. We have no clear documentation of lack of clear civil documentation of property. Yeah, we do not know what we do not know what the status of what we own according to civil law. So correctly done alienations, first of all, will respect the intention of the donors, will observe the required permissions, will have accurate appraisal of goods, and will take into account equity towards the remaining members, because we can sell until we render people into destitution. Members are not able, there's no sustainability. We cannot sustain ourselves. respect to the stable patrimony, so that what we alienate does not affect or does not jeopardize the patrimonial condition of the institute. That is what we call threatening alienation. Accurate inventory of goods. Then lastly, I want to look at some of the canonical offenses that are now related to property. Stealing of goods or preventing them from having proceeds, or preventing proceeds from being received from them. Alienating ecclesiastical goods, and carrying out administration without the proper permission. So we have to know that if now any member or those entrusted alienate goods without the required authorization, that is now an illegal act that is punishable. So it could be one of the grounds for penalty on members. Grave negligence in the administration of ecclesiastical goods. Those who commit the crime of bribery and performing financial misdeeds or unauthorized management of secular property. That I become a guarantor or I become a co-ownership of goods that are not belonging to the institute. Thank you. Okay. Yes. Yes. How we define stable patrimony? What is not designated is not stable patrimony. And moreover, it has to be named as stable patrimony. So the distinction is after naming the property, the rest will not be it. The rest can also be designated for other things, but they will not form part of the stable patrimony. Yes. Okay. This is what it means. The religious institutes are established or erected in the church as public juridic persons. They are like a public organization in the bigger entity called the church, because we exist there to fulfill the mission of Christ. Therefore, what we own, since it is geared towards the mission of the church, the overall ownership is the Pope. The Pope is the owner of all the goods in the Catholic Church. So these goods are ecclesiastical in the sense that they perform or they fulfill the works within the church. And those who have them do not own them as personal property, but they are owned for the purpose for which the church allows them to be owned. So they must follow the laws that the church has put in owning them, administering them, and alienating them. That's why they are called ecclesiastical goods. My goodness. Okay, the Episcopal conferences should make it available for all the juridic persons in the region. all parishes and all institutes in a particular Episcopal conference should be able to get that document. Also, the supreme moderators in Rome can access those documents from the dicastery, but it is the conferences to set them. Unfortunately, some conferences have not set the limits and served it to the Apostolic See. But in the case of the gap, it is important to approach the dicastery just to give the range, like what could be the limit for this particular region, because it depends with the number of Catholics and the economic situation of that region. That's what determines that limit, but it must be set by the conference. So a bishop can be approached, or the office of the president of the conference, I don't know, but it must be available. Yeah. Okay. Is that better? Okay, thank you. Okay. Historical property, I would explain it both sides. There are certain parts of the world whereby there were buildings that the states designated as historical heritage. But apparently, some institutes either bought them or live in them or use them. But according to the state, they are designated as heritage. That is part of it. And again, within our institutes, we may have properties that perhaps are associated with the history of the church there or our own beginnings, but something that the region recognizes as historical. And those can readily be known, I think, through the state and through the particular churches where we exist as institutes. Or for example, let's say the first mother house, the first house that the institute built, and where perhaps for purposes of heritage, the institute would have not want to destroy it. It would have been a small building or something, but it remains the heritage of the property, something like that. Yes, that now will not be under alienation. It will be under extraordinary administration. I would have gone into that, but it was not part of what we are talking about today. Yeah, they need to ask permission, but now not under alienation, under extraordinary administration or administration of major significance. So a little bit of just explaining. We know in our institute we have levels of authorization. There are ordinary things that can be done in community. But let's say the community wants to do something beyond the limit of their competence. They will ask the provincial. And maybe in the province, the provincial superior needs to do something or buy, they'll need to ask the supreme moderator. So that's what we call extraordinary administration. And if it goes beyond the competence of the supreme moderator, he or she has to go to the apostolic see. And those should be specified in the proper law. Yes. Yeah, thank you. Thank you, everyone.
Thank you.
Thank you.
Laura.
Thank you so much.
Sisters.
Much.